for the President of India election was issued by the Election Commission of India on 15th June 2022. I filed my nomination on 28th June 2022. That was the final day of the nomination. My nomination got through the initial scrutiny under Article 58 of the Constitution. After some time, on 30th June, the final nominations were scrutinizing. The President of India election notification was issued on 15th June 2022. I went to Delhi on 28th June 2022 and filed my nomination. On that day, my nomination got through the initial scrutiny by fulfilling the requirement under Article 58 of the Constitution of India. On that day, I fulfilled the essential qualifications. But on 30th June, the nominations were taken up for final scrutiny.
When did the President of India election take place?
The President of India election took place on 18th July 2018.
Did you file your nomination in the President of India election?
Yes, I filed my nomination on 28th, the final day of the filing of the nominations.
Whether your nomination was rejected by the returning officer?
Yes, my nomination got through the initial scrutiny on 28th June, but on the 30th, the day of the final scrutiny, the returning officer rejected my nomination on the grounds of non-fulfillment of the requirement under Section 5B1A of the President of India and the Vice President of India Election Act 1952, amended in 1974 and 1997. The section is related to the 50 members proposers and 50 members seconders from the Electoral College.
What did you do after rejection of your nomination?
Immediately after the rejection of my nomination, on the day of the final scrutiny, I went to the Supreme Court of India on 1st July 2022. On that day, I met the authorities in Supreme Court Legal Services Committee and applied for the legal aid to file an election petition or a writ petition, whatever is required to challenge the action of the returning officer.
Did you get legal aid?
No. My legal aid application should have been processed before the completion of the 30 days time prescribed by the Act. Actually, the election petition should have been challenged in the Supreme Court of India under Article 71 of the Constitution before the completion of the period of the 30 days after the completion of the election. But actually, the legal aid committee took more than that period and they finalized the legal aid application on 5th September 2022. On the day of finalization, they took a decision that I was not having the locus standi to question the election process of the President of India. Actually, it was a wrong decision. Why? Because when I was the candidate for the election process of the President of India, the Supreme Court Legal Aid Service Committee should not take such decisions. That is a erroneous decision. Immediately, I appealed to the next higher authority, the chairman of the Legal Aid Committee, by sending email and sending the post copy of the letter. But they deliberately ignored that letter, stating that you did not submit any documents. Where was the necessity for me to submit the documents? When I filed the that application, at the time I enclosed all the relevant documents. Where was the necessity of sending the documents Once again. So it was a pre-decision, it was a pre-decided matter not to give the legal aid to me. So they declared the legal aid. Afterwards, I sent one RTA application to the Supreme Court of India stating that the legal aid committee did not give me the legal aid. So you please tell me what were the reasons for rejection of the legal aid. Then they told me that your legal aid application was rejected by the Supreme Court Legal Services Committee, which is a separate department. We don't have any control on them, so we can't do anything. Is it the responsible answer from a Supreme Court of India, which is the highest judiciary in this country? You examine these things, how this judiciary is functioning. So far you are thinking that judiciary is the custodian of the constitution. Do you think that the judiciary is the custodian of the constitution? I am very much entitled for the legal aid. Why the legal aid committee did not give me the legal aid? Why I didn't have the locus standi? When I was a candidate, when I fulfilled the initial requirement under the constitution, whether are they competent enough to decline my legal aid application simply on the ground that I didn't have locus standi? So it was the erroneous decision of the Supreme Court Legal Services Committee, and at the same time it was the erroneous decision of the Supreme Court itself.
After rejection of the legal aid, what do you do?
After rejection of the legal aid, I was left with no option but to write to the Supreme Court directly. I did the same thing. On 1st September 2022, I wrote a letter to the Chief Justice of the Supreme Court of India informing him that the election process was illegal. Why? Because the election process was conducted on the basis of a section. What is that section? That section is 5B1A of the President and Vice President of India Election Act 1952. That section is the primary contention in the election process. Actually, this section was upheld by the Supreme Court of India thrice in tackling the repetitions from some private parties. They upheld the Supreme Court decision stating that the conditions which were framed under the Legislative Act are reasonable conditions. So you should not question them. So these reasonable conditions are framed in good faith and good intention. So we are upholding them. Moreover, they are not at all violating the equality. I don't know what equality they are talking about. Anyhow, they upheld that provision, stating that, thinking that it was a valid legal norm. But actually, it was not at all a valid legal norm. It was a null. It was the blind faith of the Supreme Court of India. It was the blindness of the Supreme Court of India to think that it was a valid legal norm. Because whenever there is a conflict between the higher constitutional norm and the lower legislative norm, the lower legislative norm loses its validity and becomes null. So, in the instant case also, Article 58 of the Constitution is a higher constitutional norm. But the Section 5B1 is a lower legislative norm. When okay, so what happened? The section which I am contesting is a null. Why? Because the section is a parliamentary legislation, which is a lower norm. The higher constitutional norm, Article 58. So, the section we are talking about at present is a null. Null means it is not at all a legal norm. To remove that one, nobody should go to the court of law because it is beyond the legal process. When there is a conflict between the higher norm and the lower norm, automatically the higher norm trumps the lower norm, so it becomes null, it has no validity at all. Such a illegal section is the backbone of the President of India election. How can we justify this issue? They rejected my nomination on the basis of that null only. They validated the nominations of the Draupadi Murmu and Mr. Yashwant Sinha based on the same null. Now you think about what was the validity of Mrs. Draupadi Murmu's nomination. the nomination of Mrs Draupadi Murmu was invalid. When the nomination was invalid, how these electors belonging to the Lok Sabha and Rajya Sabha and the other state legislative assemblies voted for such a candidate? They were supposed to know the constitution and the law. Such elect people voted for such a null. Now you can imagine what is the position of the state of India at present. What is the democracy we are following at present?
How can you say that the President of India election was null and void ab initio?
I can say that the President of India election was null and void ab initio because the President of India election was primarily held on the basis of a section 5B1A. That section is a null. I have already stated that it is a null. When that section was null, the nominations of the two candidates, Mr. Yashwant Sinha and Mrs. Draupadi Murmu, were validated on the basis of the same section. The remaining candidates lost their validation of the nominations because of the non-fulfillment of the requirement of that particular section only. When the section was null, how the returning officer, the Election Commission of India, how the Supreme Court of India upheld that null? Now you can imagine what is the null means. Null means it is not at all legal now. When it is not at all legal now, how the returning officer decided that it was a valid legal norm and conducted the election? Who voted for that candidate? These so-called parliamentarians, they voted for that candidate. Where was the candidate? There was no candidate. The candidate was invalid. What about the validity of the votes? The votes were invalid. Under those given circumstances, is it not correct on my part to say that the President of India election was null and void ab initio? It was certainly a null and void ab initio, as on the date of the swearing-in ceremony on 25th July 2022, Mrs. Draupadi Murmu was not a President of India under Article 60 of the Constitution. Anybody should be sworn in to the position of the President of India who was a President as on that day.
When was the swearing-in ceremony conducted to Mrs. Draupadi Murmu?
Immediately after the declaration of the result of the presidential election, I think it was on 21st or 22nd, the returning officer of the Election Commission of India declared that Mrs. Draupadi Murmu has been duly elected to the position of the President of India. Now you can imagine whether it was correct or incorrect, whether she was duly elected. Where was the question of election? Where was the question of the nominations? All were null. How that returning officer declared that it was a duly elected position. So, based on that declaration, the Chief Justice, at that time Mr. N.V. Ramana was the Chief Justice of the Supreme Court of India. He conducted the swearing-in ceremony on 25th July 2022 in the august body of all the eminent politicians of India. Now you can imagine the acumen of our politicians. So, he conducted the swearing-in ceremony. To whom he conducted the swearing-in ceremony? He conducted the swearing-in ceremony who was not at all a president under Article 60 of the Constitution as on that day. The so-called Chief Justice of the Supreme Court, who was the upholder of the Constitution, who was the interpreter of the Constitution, conducted the swearing-in ceremony. Now you can imagine what is the situation of the democracy in this country. Now you can imagine what is the status of the Supreme Court in India. Whether the Supreme Court is delivering all the judgments constitutionally. I will deal with the matter after some time.
Did you find any illegality or unconstitutionality in the swearing-in ceremony?
Yes. It was certainly an illegal and unconstitutional matter. Why? Because certainly it was illegal and unconstitutional. Why? Because Why? Because as on the day of swearing-in ceremony, Mrs. Draupadi Murmu was not at all a President of India. I already explained to you the null and void ab initio of the presidential election. So, when the presidential election was null and void ab initio, it is certainly illegal and unconstitutional.
Did you file a complaint against the then Chief Justice of the Supreme Court of India?
Yes, I filed a complaint against the Chief Justice of the Supreme Court of India to the then Lok Sabha Speaker. At that time, Mr. Balram Chakra was the Speaker. No, sorry. Mr. Om Birla was the Speaker at that time. I wrote a letter to Mr. Speaker stating that Mr. N.V. Ramana of the Supreme Court of India conducted a swearing-in ceremony to Mrs. Draupadi Murmu. The swearing-in ceremony was unconstitutional and illegal. Due to the conduction of the swearing-in ceremony, Mr. Ramana catapulted Mrs. Draupadi Murmu into the position of the President of India. It was a very unconstitutional act because she was not at all a President of India. So, such a person occupying the position means the office of the President of India becomes illegal. When the President of India becomes illegal, there occurs a break or vacuum in the position of the President of India. So, I narrated vividly about the violation of the Constitution by the then Chief Justice of the Supreme Court of India, but the Speaker did not care about it. He simply handed over the matter to the Lok Sabha Secretariat. On my written complaint in the form of RTI, the Lok Sabha Secretariat answered in a very lenient way, thinking that it was a very small matter. Whether the matter has to be handed over to the Secretariat to completely to the person who is a clerk. So, on my complaint, on my RTI reply, I didn't get the proper reply.
What was the outcome of the complaint?
He did not take any action. He simply put it in the dustbin. No action was taken. Immediately after inaction, I wrote once again to the Chief Justice of the Supreme Court of India. The then Chief Justice of the Supreme Court of India also did not take any action. Actually, it was a very bad precedent in India. When the mistakes occur within the organs of the state, there is a checks and balances under Article 375. These people have to exercise the powers under Article 375 and check the abuse of power by one organ by the other organ. But the Supreme Court simply lodged it.
Do you think the present position of the office of the President of India is legal and unconstitutional?
Yes, it is certainly illegal. It is certainly illegal because I told you already, she was not a President of India as on 25/7/2022 as per Article 60 of the Constitution. When she was not at all a President of India on that day, how the Chief Justice of the Supreme Court of India conducted the swearing-in ceremony to Mrs. Draupadi Murmu? It was a very unconstitutional, illegal act done by the erstwhile Chief Justice of the Supreme Court of India.
Do you think that there is a gap or vacuum in the position of the office of the President of India?
Yes, certainly there is a gap. As for Article 52, there shall be a President of India. What does it mean? There should not be any break in the office of the President of India. The office of the President of India should be continuous. If any break occurs, what will happen? Do you know? The entire government will collapse. The three organs will lose their validity. Without having the basic knowledge, you conducted a swearing ceremony to an illegal candidate. The occupation of the position by the illegal candidate was not checked even after my written complaint to the Supreme Court of India. It was not a petition, it was a notice to the Supreme Court of India. That notice was lodged stating that it was not a pill. You should understand what is pill and what is notice. It was a notice to you. You committed a certain mistake, you rectify your mistake. But you did not rectify your mistake, simply lodging it as a pill. So, what happened? The erroneous President of India who occupied the position is continuing in the position even today. So, what happened? There is a break. The position should be occupied by a legally valid candidate. She is an illegal occupant. So, there is a break in the position of the President of India. When the break occurs, all the three organs will lose their validity. After losing their validity, the government will lose its validity. The loss of the government results in the loss of sovereignty. Both the loss of sovereignty and the loss of government results in the loss of statehood. when the state is no more a state in the eyes of the international law, why the UN should retain its membership? This is the primary question of the Supreme Court of India, and directly the addressing the letters or mails to the Supreme Court of India. In those letters, I wrote very clearly stating that the present incumbent Mrs Draupadi Murmu is occupying the position illegally. She is occupying the position illegally, so she needs to be removed. In that place, I should be installed as the President of India. I also urged the Supreme Court of India, at least you give some direction to the concerned authorities to grant me 100 lakhs loan as the immediate relief so as to ameliorate my financial distress. But nobody is caring. Next.
The above analysis reveals that there is a violation of domestic law and the laws of statehood of the state of India. Do you bring this matter to the notice of the UNO?
I certainly brought the matter to the notice of the UNO. When I was writing a letter to the Chief Justice of the Supreme Court of India on 1st September 2022, on 27/8/2022, one letter was addressed to the UN Secretary General and the UN International Court of Justice. And one more letter was addressed to the UN. Based on those two letters, the UN gave me a reply stating that the matter was pertaining to domestic jurisdiction of the particular country. So, we can't intervene in a situation where the domestic jurisdiction is involved. Actually, what was the knowledge of the UNO? Now I am questioning. Where was the domestic jurisdiction to this country? When the domestic jurisdiction is available, as long as a country, as long as a state follows the domestic law. When the state is violating the domestic law, where is the question of the domestic jurisdiction? This kind of common sense is lacking on the part of the UNO. The UNO simply stated that we can't intervene in domestic jurisdiction. Yes, there is an article 27 in the charter of the UN. Under the charter, the state of India has a sovereign immunity. But where is the sovereign immunity on the day when the head of the state was illegal? The entire government has collapsed. When the government was collapsed, there is no sovereignty, there is no government, there is no rule of law. Where is the sovereign immunity? Couldn't they understand? They simply told that we can't intervene in such a situation. Afterwards also several letters were addressed to the UN. Even today bunch of letters were addressed to the UN. But it is also not caring what the UN is doing. They are talking about the rule of law. They are talking about the lawful relations among the nations. Can they maintain lawful relations by violating the rules in the domestic sphere? So I informed them.
Finally, what are you going to do? Claim your right place as a President of India.
As I told you already, as for law, there is no government in the state of India. All the three organs have lost their legal relevance as on the day of the 25/7/2022. There is no Supreme Court, there is no legislature, there is no executive. How these people are discharging their duties, it will be taken into account after some time. Okay? When there is no organization here, I don't think these people will do any rectification in the process. It has to be rectified at the international level only. I have to certainly approach the International Court of Justice or the UN Secretariat or any organ which is relevant to the international law. When the country loses its government, when the country loses its sovereignty, it is the International Court of Justice or international organization which has to address this problem. They have to certainly interfere in the matter, but they are also maintaining silence. How these people are maintaining silence, it will be answered in a due course of time. Anyhow, I have no option but to approach the International Court of Justice. But as of today, International Court of Justice is giving jurisdiction to the states only. Individuals are not having any jurisdiction, but they should understand that individual has also jurisdiction due to the nature of the law. The law is hierarchical. It is not a coordination. The international law has to check the violations in domestic law, and not only that, the individual is the subject before international law. When he is a subject before international law, the International Court of Justice should have certainly provided the jurisdiction to the individual. That matter I will explore in due course of time. So the ball is in the International Court of Justice and the ball is in the UNO. The Indian government has lost its relevance. It cannot solve this matter.